Hello and welcome to Sit Down with the Chief. We're here with editor Richard Steier, who's going to talk about the Supreme Court decision to review the Janus case, which questions whether public employee unions can collect agency fees from non-members. Richard?
Basically, this is a continuation of the attempt by wealthy right-wing interests to try and weaken public employee unions by taking away a source of income for them. In essence, it's challenging a 40-year-old Supreme Court decision in a Detroit case known as Abood, in which it was decided that they were entitled to collect fees from non-members, but non-members not wishing to have any portion of the equivalent of dues used for political action could have that money rebated to them. That 40-year-old decision seemed to do a good job of sorting out the equities. That, in essence, if you've chosen by being a non-member not to participate in the union because you don't like its ideology or you don't like some of the political candidates that it's endorsing, that you don't have to pay in that portion of it. The other portions of it, though, are for matters including collective bargaining and grievances, two of the prime duties for a union, and things that benefit members. If not every single member, then a lot of members at some point or another. And the argument that is being made in this case, as was made in a case out in California that wound up deadlocked at the Supreme Court last year after Antonin Scalia died, is that anything that a union is doing is political and has an impact on the wider world. In other words, if you're getting a 5% increase instead of a 2% increase or a pay freeze, that is forcing the government to make decisions that these employees might not necessarily agree with. Now, you would have to figure that there's one of two explanations here. An employee that's looking to take away something that acts in that employee's best interests, like pay raises, is either a sap or they're a tool of these wealthy interests who are funding it. There is no question that on the merits that this case should be tossed by the Supreme Court, that it should dismiss it. But there is concern because of Neil Gorsuch having become the 9th member of the court and potentially the 5th vote against the union interests here, that this could be a decision that would have a significant impact on the unions. That the most extreme example that's been tossed out there is during a transit strike that took place in late 2005, one of the penalties that was imposed was the loss of dues checkoff rights for TW Local 100. When that happened, they reached a point where less than half of the members were paying dues voluntarily by hand, which was the old-fashioned way to do it before you could just do it by payroll deduction. And that was an extreme example that union members were angry, A, because they got saddled with having to pay a portion of their health care coverage for the first time, and B, because under the Taylor law they also lost 6 days' pay for the 3 days that they were out on strike. But it doesn't matter if it's going to be 25% of people or 10% of people, that the unions are not in a position at this point where they can afford to be weakened by any loss of dues income. And so that they are doing what they can, but ultimately you've got 9 people in robes who are going to make the decision, probably not greatly influenced by public opinion. And so this becomes a real test and could lead to a real weakening of public employee strengths. And the reason for that is that once you say that non-members aren't obligated to contribute for these benefits, it's very possible that there are people who are members and who have just paid in all along say, hey, if I can freeload, why wouldn't I do the same thing? And would decide that they're not going to pay in anymore. It wouldn't be in their self-interest to do so, but sometimes people do funny things.
Thank you, Richard Steier, and thank you for watching Sit Down with the Chief.